The Alberta budget is being announced next Thursday, and there's one group of business owners and consumers that are waiting on the decision as to whether the unconstitutional beer tax will be rolled back in light of an injunction that was granted to Steam Whistle recently. The tax that was implemented in October of 2015 saw increases of up to $1.05 per litre for beer producers and importers outside of British Columbia, Alberta, and Saskatchewan wanting to sell their product in the province. I talked to Derek Frum at the Canadian Constitution Foundation, who has been following up on the Steam Whistle case, in which the argument is built on Section 121 of the Constitution, and in particular, the Gold Seal decision from 1921. In that decision, the court decided that only financial penalties applied to the free trade provision in the Constitution. Here's what Derek had to say about the legalities of the tax.
The Alberta government has actually infringed the Constitution as it has been circumscribed. So this 1921 decision, this Gold Seal decision, said it only applies to protectionist taxes, tariffs, and the like. Well, that's exactly what Alberta's tried to do. So the entire case law on Section 121 is against the Alberta government. The Alberta government doesn't have a leg to stand on here. This tax that they've brought in to protect local breweries is clearly contrary to the Constitution. It would be an incredibly novel argument you would have to convince the courts to accept otherwise, and I just don't see that working for the Alberta government.
We also talked about some of the repercussions that the Alberta NDP would face if the decision to illegally tax imports is not overturned. Here.
The government of Alberta would have to convince the court to overturn almost 100 years of case law on this topic to convince them that this tax was okay. And I just don't see that happening, especially in the current economic climate when agreements coming in now are governments recognize world round that free trade is actually beneficial for all the parties involved. And I'm not sure why the government of Alberta was convinced in this case that offering a protectionist tax for local brewers would somehow work out in the one time that they've done it.
Derek also tells me that he sent a letter to Joe Ceci, Minister of Finance, addressing the unconstitutional tax and didn't get a response. Steam Whistle was the first brewer to challenge the new taxes in court, and as mentioned, they've been granted an injunction. But now the Ontario craft brewers have planned to file a class action lawsuit, and we should expect to see more brewers and importers backing these challenges. For now, producers and importers, along with small business owners and consumers, are hoping to see this decision axed in the budget next week. Otherwise, a decision on the Steam Whistle case will be made by courts in July of this year. For the Rebel.media, I'm Holly Nicholas.
Thanks for watching. Click here to never miss a Rebel update. Want even more of the Rebel? Well, click here to become a premium member.